is the procedure that is being followed here is unheard of. That cannot be equated to mean that the court does not know the procedure, my lord. Now, the issue is, my lord, there are issues which have been raised here. Procedure at which we are now, which is an application in terms of section 174, does not allow parties who have not made an application in terms of that section to respond to the issues which the court needs to determine. Accused number 1 and accused number 3, accused number 5 and accused number 2 are not party to these applications. And yet there is evidence which in their mind seems to be evidence that is being introduced through the back door, my lord. Would we then be afforded the opportunity to respond? And the court said on Monday, yes, you will then respond. But state proceeds, still continues to introduce new evidence.
Okay, so are we...
Through the back door, my lord. Well, I don't know if this procedure, if the court really affirms this procedure, I'm in the hands of the court.
Don't talk about the procedure, because I'm telling you what you do in my absence.
No, but my lord, there was no agreement. There is no agreement that we have...
But you spoke to him.
About what, my lord? We spoke to him about what?
Okay, fine. That's it.
I never speak to the state, my lord, because I know the way in which they operate. Everything that I do, I make it a point that it is done on record. I know the way in which they operate.
As we pointed out, that is, we're responding to their complaint on Monday that they were not made aware of the proceedings. But, my lord, we've made submissions. We have summarized the evidence. All that we are saying is stating the obvious, that in considering the conspectus of the evidence, these are the issues that are already on record that must be factored into the equation. Nothing new. We're putting on record what ought to be considered. I don't understand the objection by my learned friend. Nothing, no new application. We're just saying the court, as we have done, we have summarized the evidence. These are aspects that we could have mentioned in the summary of our evidence. We're just saying, in addition to the summary that we've given, these are also the aspects that must be factored into that summary. Nothing new, my lord.
Okay, is that the end of the argument?
Yes. So
what do we do?
Yes. I think Advocate Numalo wanted to respond to the state's submissions, and that's where we are in terms of the process. But there was that one aspect that we wanted to put in record that appears on Exhibit EE, which would form part of, which forms part of our submission as far as accused number 4 is concerned. And as I say, this is not something new; it's already on record. The proceedings of 27 October 2020, page 5. The last 2 lines, accused number 4, Your Worship, I do not see the necessity in acquiring legal assistance because we do not have money since we've been brought before court. The people who are supposed to be appearing before court are not before court because they have money. That's all that we wanted to put in the report.
Okay, fine. Yes, yes. Is that the end of this application now?
Yes, those are our submissions, my lord.
Yes, Mr. Normal, are you through too?
My lord, I'm not in a position to respond because in respect of the statement of Makaleni, the 7 requirements in terms of the Act have not been met. I've never heard the state discussing the issue of the nature of the proceedings, the nature of the evidence, the purpose for which the evidence is tendered, and the property value of the evidence of that statement. In fact, my lord, in my address...
You're not quoting the SC Act, I mean the Constitutional Court case of Datsi. You're not quoting that case, sir?
No.
Yes, the one that we quoted, my lord, it's Kappa.
Because it is the...
Kappa.
Yeah, it is the Constitutional Court speaking there. It's not the...
The Act speaks
Yeah.
The Constitutional Court refers to an act. So
Yeah.
when an application is made, the seven
It's a judgment
requirements.
of the Constitutional Court. What
Yes.
more do you want me to say?
Yes, I know
And
that.
he's reading that judgment.
Yes,
And that judgment says there are 7 categories which must be satisfied.
yes, yes.
So what is the problem?
Has the state satisfied those requirements?
I don't know if I'm saying that judgment, as I understand it, that's what it says.
I understand, my dad. Further to that, in my application, I never referred to the statement of Makalene. So how does it find its way through this court in this
Yeah,
application?
fine, you can argue that if you want.
Because, my daughter, I've referred this court to the case of Mkedezi to say that for the 5 requirements, they must be met for my client to say he formed common purpose with the others. But now the state is referring to the Makaleni statement, of which I never referred to Makaleni, as to how Makaleni and accused number 4 is related in respect of this application that I've
Yeah, you
dealt
can
with.
argue that I must reject that argument.
That is my argument,
Yeah,
my
fine.
daughter, that I respectfully ask the court to reject that evidence.
Yeah.
It finds no application in the application that I've made before this court on the 25th of August. That was
Okay.
on Monday. Thank you, my daughter. Thank you.
Right, so when do we reconvene?
So, my Lord, may I perhaps find clarification? On Tuesday, when the issue of Makaleni reared its ugly head, Advocate Munisi stood up and inquired from the court whether, because of that, the Makaleni issue, which was not canvassed in Advocate Ngumalo's application, and it does touch on particularly Mr. Ntanzi. And further, my Lord, regarding the manner in which the response by the state seeks to have the extracurricular statements of accused number 2 apply to all accused persons that are before court, which is anti the Mhlongo case. So on that basis, Mr. Advocate Munisi asked whether we will be afforded an opportunity to reply, and the court confirmed that we could reply. Hence, in the morning, I was asking, is that procedure? Because those are fundamental issues in this application, my Lord. It has escaped the circumscription for the application and the reply. Now we are in Stswana. We are touched by blood that was not meant for us.
You know what? If you guys apply the law, and you know the law, there won't be problems. If he knows the law and he applies it, there are no problems. If he does the same, he applies the law and does it, and he argues, and you say, I must write a judgment. I'll write a judgment because I know the law.
Yeah, because we found ourselves perplexed.
So
whether-
if you want to supplement your heads, you can do it, no problem. If you think it's necessary.
My Lord, I stand as an officer of the court because I did not per se make an application. But if I see issues that I feel as an officer of the court that things are not going well, my Lord, I should stand up and ventilate and assist.
I can tell
If
you what
can.
is your problem.
Yes. What is my problem, my Lord?
If you read that charge sheet,
Yes.
it says the 5 gentlemen there are charged in terms of section, common purpose, and then it's section 51 what?
It's 51.
Just read 51.1, because that is the problem, I can tell you now. Jesus.
It's more